So, good afternoon, everyone. We are glad to have everyone at the Permanent Forum on Genocide and Crimes Against Humanity. And we're delighted to have the honor to welcome Professor Dirk Lady. He's judge at the International Court of Justice since 2024 and distinguished visiting professor at the University of Johannesburg since 2025. His lecture will be about the relationship between use cogents and genocide, a legal perspective. So please, Professor Dirk, the microphone is yours, and we'd like to thank you once again for your presence here.
Thank you. Thank you very much, Arthur. It's a pleasure to see you. And I'm grateful to everyone who has made the time to come and listen to me. I want to thank very much the University of São Paulo, especially the Permanent Forum on genocide and crimes against humanity for this initiative, and also especially for inviting me. And I'm particularly glad, Arthur, you and I have been speaking about this thing, I think, um, since last year sometime, I think just after June. So I'm really glad that we were finally able to get it done. In fact, I was so excited that I think I told you that I thought it was happening on Monday, and on Monday I would have clicked in already to give this presentation. So thank you again very much. I should begin by making the normal caveats that people give in these situations. So obviously, nothing that I say can and should be attributed to the International Court of Justice. And secondly, and I think maybe more importantly, there are at the moment four genocide-related cases before the International Court of Justice. There is the South Africa versus Israel. There's Nicaragua versus Germany. There's Ukraine versus Russia, and of course there's Myanmar versus Gambia. These are all very interesting cases, and I would very much like to speak about them. But unfortunately, my judicial role, and just the possibility of sort of straying, suggests that I should perhaps not say much about them. Of course, I may mention them here and there, but I will not say much about them. So, so Arthur asked me to speak about the relationship between genocide and Muskogeans. It's a fascinating topic. Um, I guess if somebody asked me what is the relationship between genocide and Muskogeans, I could say, well, the prohibition on genocide is Muskogeans. And I could end there, but I don't think Arthur will be very happy. So he wants me to say something a bit more. So maybe I'll dig a little bit into that statement that the prohibition of genocide is jus cogens. I'll start off. I think it'll be useful to start off with some conceptual or terminological issues. The first set of conceptual or terminological issues relate to genocide. So let me just start off with genocide. Um, and maybe before speaking about genocide, I'll just say the crime of aggression, which is related to the prohibition on the use of force, is regarded by many as the crime of crimes. And that might make one think maybe that's the most important crime in sort of, those crimes that we refer to as the most serious crimes of concern to the international community. But I think genocide is the most serious one. The crime of aggression is referred to as the crime of crimes because it often leads to the other crimes, right? So aggression often leads to genocide, crimes against humanity, and war crimes. But genocide is the most heinous of these crimes. I think it's the most evil of these crimes. This crime, which I think is the most heinous, is prohibited both under the Genocide Convention or the Convention on the Prevention and Punishment of Genocide of 1948. It's also prohibited under custom international law, but as I've said, it's also a norm of use cogens. The Prevention and Punishment of the Crime of Genocide defines genocide by reference to a number of acts such as enslavement, murder, and then it says when these acts are committed with the intention to destroy in part or in whole national, ethnic, racial, religious group. And by the way, I think that this is not a closed list, but it's so I mentioned this point because the threshold for the commission of this particular crime is very high. So you can commit atrocities, atrocious acts, and everybody recognizes that these are atrocious acts. But because of this requirement of intention and the high threshold of intention, it's often very difficult to prove genocide. So that's the first set of conceptual issues, just broadly about genocide. The second conceptual issue or set of issues that I want to speak about relates to jus cogens. I'm often asked because in my previous life I was a special rapporteur, I was the IRC special rapporteur on jus cogens. I'm often asked, how would I describe or define jus cogens? And my answer is often, when I speak to non-lawyers, my answer is often, well, jus cogens norms are those norms that we consider to be the most important. But of course, international lawyers will tell you, well, but Dira, that's not very precise. So you need something a lot more precise. And of course, they might point you to the technical definition that we find in the Vienna Convention, which is those norms of international law from which no derogation is permitted, right? So those norms of international law from which you cannot derogate. I would say that these two definitions, the more technically correct one and my imprecise one, are not mutually exclusive. So if you were to put them together, you might say something like norms of jus cogens are those norms which are so important that no derogation from them is permitted. So their importance leads to no derogation. If you are a student of international law, you know that this is not a small thing, right? If you are a student of international law, you know that this very notion that there are certain norms that are non-derogable is a challenge to the very foundations of international law. Because the context is that international law is so if you think about domestic law, it's very vertical, right? There's always a government, right? And the government makes the law for the subjects, and subjects cannot decide, well, we don't want this particular law to apply to us. But international law, it's different, right? It's a horizontal system. And so because it's horizontal, the subjects of law, the states, are also the makers of law, right? Because of that, states are always to contract, they're always able to contract out of rules. So think about the most, I don't know, rules of international law relating to, say, immunity. A group of states can say there is this general rule on international law, but as between us, we are agreeing that we will not apply the general rule of international law. In fact, this is your typical example is the Rome Statute, right? So the Rome Statute says there is a rule of international law in which the immunity of officials will be respected. But the Rome Statute includes an article, Article 7, which says we are going to derogate from that rule. As between us, this rule will not apply, at least in respect of the International Criminal Court or at least in respect of indictments and arrest warrants that have been issued by the International Criminal Court, right? So that's an example of a derogation. I can give another example of a derogation. So there's a rule in international law that the exclusive economic zone, which is a zone in the sea, 200 nautical miles from the baseline or 200 nautical miles from the coast, that only the coastal state is entitled to exploit the resources there. But a group of states can get together and adopt a treaty and derogate from that general rule, right? And say, as between us, we don't recognize the exclusivity so that's derogation. But these norms, these jus cogens norms, are so special that that's not permitted, right? It goes against the very foundations of international law, the very character of international law. So this is why jus cogens is a big deal. Jus cogens is such a big deal that there's one professor who once noted that jus cogens has or shares the same initials as Jesus Christ, right? And Jesus Christ could walk on water, turn water into wine, right? And so use Kogan's is just as powerful, right? It does the miraculous, so to speak. So much so that when the commission was considering, when the ILC um, was considering placing this topic of use Kogan's on its agenda, there was one member of the commission at the time who's now also a member of the International Court of Justice who said there are certain topics that are so special that even for the ILC, they have to be above the glass ceiling, right? Because it's that important. So that's the context. I've spoken a little bit about what genocide and the prohibition of genocide is on international law. And then I've said something about Use Kogan's and what Use Kogan's is and sort of how it operates and why Use Kogan's is such a big deal. So now, with that context in mind, it becomes possible to speak about the relationship between these two concepts beyond the fact that one, the prohibition of use Kogan's is the other. I'm sorry, the prohibition of genocide is use Kogan's. Now, I've already told you that the concept of use Kogan's, the notion of use Kogan's, the idea of use Kogan's challenges the most fundamental structural assumption of international law, which is horizontality, right? And so use Kogan says international law may be a horizontal system, but we are in effect going to verticalize it, at least with respect to use Kogan's law. What I have not told you, at least haven't told you yet, is that the acceptance of this, there's no other way to put it except to say this radical notion. The acceptance of this radical notion in international law in the 1960s through a process that started in the early 1950s was nothing less than a revolution, right? So in 1969, the states, a group of states in Vienna, adopted the Vienna Convention on the Law of Treaties, which becomes one of the most basic instruments of international law. In this treaty, the Vienna Convention on the Law of Treaties, there's one provision. It's called Article 50. Well, it's numbered Article 53, and it starts off by saying treaties that are in conflict with norms of jus cogens are void. That's a big statement. So you're saying a treaty that is adopted in accordance with the procedures and processes of international law is void if it conflicts with jus cogens, because that's a form of derogation, right? That's a big statement. That's a big statement. The adoption of this convention in 1969, followed a rather long and arduous process with many, many special rapporteurs. Well, I should say it first began within the ILC. So the ILC was tasked with codifying and progressively developing the rules of international law relating to treaties and treaty making and the consequences of treaties and so on. And it had a number of special rapporteurs. The most significant special rapporteurs with respect to use Kogan's were the great, British special rapporteurs are Hirsch Lauterpacht, Fitzmaurice, and Humphrey Waldock, and all of them in different ways contributed to the development of international law. What was interesting, though, is that each three of them, when they introduced the concept of jus cogens, there was hardly any negative reaction, whether within the International Law Commission or from states. And yet, if you look at the time, the concept of jus cogens, while it was, of course, known in academic literature, there was very little pedigree for this concept outside of academic circles. Right? It would be very difficult to find in the practice of states circumstances in which jus cogens was, in fact, invoked. Right? There are examples, and if you read some of the writings on the history of jus cogens, you will find, for example, there's a famous separate opinion by Judge Schuking in the Oscar Chin case in the in the predecessor of the International Court of Justice, the Permanent Court of International Justice. But even that wasn't real Euskogans. I mean, he uses the word or the phrase Euskogans, the concept Euskogans. But what he was talking about was he was talking about the invalidity of a treaty on account of an earlier treaty. Right? This is not real Euskogans. Huh? It's not norms from which no derogations are permitted, right? It's a treaty rule and so on. There are instances in which Article 18 of the Covenant of the League of Nations has been referred as Euskogans or as having the character of Euskogans. But again, if you are familiar with Euskogans, you know that this is not Euskogans. So it is incredible that even with the dearth of practice and the dearth of references to Euskogans outside of academic literature, that this concept was generally accepted. I say generally accepted. I know that again in the literature there is often talk that France, did not accept this concept. But the truth is that if you look at the records of the Vienna Convention, the Vienna Conference on the Law of Treaties, even France accepted the concept of jus cogens. I mean, France was concerned about the implications of jus cogens, but essentially France accepted this notion of jus cogens. So what was interesting about the whole process from the 1950s until 1969 was through the interaction of the International Law Commission and the Vienna Conference, jus cogens went from the periphery of international law into the mainstream of international law. I mean, it has to be seen as a mainstream because the Vienna Convention is a mainstream document. And now here it is, reflected in one of the most important and fundamental instruments of international law, namely the Vienna Convention. So this should lead you to ask the question, why? Why is it that something as radical, as revolutionary, as divine as jus cogens was accepted so easily into the mainstream? Why is it that it wasn't questioned by members of the International Law Commission? Why is it that states, when commenting on the work of the International Law Commission, didn't question this concept? Why is it that when states, when they were taking the work of the International Law Commission and turning it into the Vienna Convention on the Law of Treaties in the late 1960s up to 1969, why didn't they question? Why did this concept survive into the Vienna Convention? Well, the answer is simple. The answer is because of genocide. I mean, think about the historical context here. The ILC starts working on the draft articles on the law of treaties in the late 1950s. So, sorry, in the early 1950s. What had just happened? The world had witnessed genocide, right? The atrocities of World War II, the commission of genocide in that context made it much easier, made it much more possible for a radical instrument or a radical concept such as jus cogens to be accepted. Remember that international law, like all legal systems, have to be able to adapt and evolve in response to developments. And these developments can be technological, they can be moral, and they can be political, right? So it is so the possibility for the acceptance of the concept of jus cogens was in many ways made possible by as a response to the atrocities of the Second World War and in particular genocides that has been committed there. I'm often asked the question, why is it that racial discrimination is regarded as jus cogens, but not other discriminations which may be equally egregious? I don't know the answer, but my suspicion is it's because of the history of apartheid. It's because of the history of colonization, and all of these things are happening in the 1960s, 1970s, 1980s, and so on. With the emergence of jus cogens, makes it possible or at least makes it easier for them to be accepted. The point is, in the face of the genocide that had just been committed, that the quote unquote international community, and I know Arthur is very surprised that I'm speaking about the international community because I have doubts about that concept, but in any event, it would have been very difficult at that time for anyone to raise their hand and say, I don't accept this concept that says there are certain things that you're not allowed to do no matter what, right? Because the question would immediately be asked, do you think it's okay to commit genocide? Do you think it's okay for states to come together and reach an agreement that, as between us, we can commit genocide against our people? So that I think, at least for me, is what made it possible for the concept of use Coggins to be accepted. So there you have already a very important relationship. Use Coggins moves from the periphery of international law. It moves into the center of international law, but it does so mainly because it does so mainly because of the commission or the act of genocide that had been perpetrated in the 1940s. So you would think you have 1966 and 1969. So you would think, well, now you have this concept, and it's part of the mainstream of international law. So all should be well. But again, if you're a student of international law, you will know that even though these Coggins had now moved into the mainstream of international law, out from the shadows, it was still a concept that was hardly ever used. There are some great international lawyers that have come up with very interesting metaphors. I'm sure you might have heard of the metaphor. Use Coggins is like a car that is stuck in a garage. I used to say, well, use Coggins can't just be a car. It has to be a Bentley. So use Coggins is like a Bentley that's sort of stuck in a garage, right? So even with the adoption of the Vienna Convention, there isn't um, much reference to use Coggins, right? There isn't much reference to use Coggins, in particular, by the court of which I'm a part. Of course, there were some courts and tribunals, and the Inter-American Court is a typical example of a court that has not shied away from identifying norms of these Coggins. Um, and of course, you've also had some other developments, for example, in the International Law Commission, with the elaboration of the Articles on State Responsibility, the principles on fragmentation, reservation to treaties, and unilateral acts, and so on, which kind of kept use Coggins alive. So in the mainstream, but struggling a little bit. My own court, the International Court of Justice, as I said, uh, developed some really interesting it developed some really interesting what I call avoidance techniques to avoid referring to use Coggins. The one technique which is you can find it in the famous military and paramilitary activities case between Nicaragua and the United States, where the question, I guess, was what was the status of the prohibition on the use of force. And the court says, I'd like to sort of, read it a little bit. The court says, um, the International Law Commission, and I want you to listen to the nuance. Now it says, the International Law Commission, in the course of its work on the codification of the law of treaties, expressed the view that, quote, the law of the Charter concerning the prohibition of the use of force in itself constitutes a conspicuous example of a rule of international law having the character of use Coggins. Note, many people have used that phrase, that quotation to say the International Court of Justice has recognized the prohibition on the use of force as use Coggins. And of course, I also have done so because, when you make arguments, you make arguments. But if you listen carefully to that quotation, you will see the court never itself says that the prohibition on the use of force is use Coggins. The court says the International Law Commission has said so, and it itself doesn't express a view. I think it was a similar thing with the court in jurisdictional immunities of state, Germany versus Italy. There as well, the court says, crimes against humanity are often referred to as use Coggins. It doesn't itself opine on whether or not this assertion is correct. So that's the one avoidance technique that the court has used. Another avoidance technique that the court has used is the court uses words that sound like use Coggins. It sounds like this must mean use Kogan. So if the court says, for example, in the nuclear advisory, in the nuclear weapons advisory opinion, if the court says certain principles are intransgressible principles of international law, intransgressible. Well, first, I don't know what that word means. But it sounds a lot like these are rules that you're not allowed to transgress. Well, I think all rules are rules that you're not allowed to transgress. But the court is saying something here without actually saying what it wants to say. It's clear to me that the court here wants to say that these IHL principles that it was referring to are principles of jus cogens, but for some reason the court could not reach agreement to say those words, and so intransgressible. It says intransgressible principles of international law. Another avoidance technique that the court has used in the past is to use what one might call clumsy or convoluted expressions. I've now been in the court for a year and a half, and I can tell you that the drafting is very meticulous. And so when the court drafts something that's clumsy and convoluted, it's not because the court is useless. It's probably because they're doing it on purpose. A typical example here is the Kosovo advisory opinion of 2010, where the court is talking about whether or not a unilateral declaration of independence is unlawful. And then it says, well, there have been determinations that such declarations in the past were unlawful, but it says it's not because they were unilateral, the court says. And again, I'd like to read, it says, the unlawfulness came from the fact that they were or would have been connected with the unlawful use of force or other egregious violations of general international law, in particular those of peremptory character. If you are listening to that, your first reaction might be, well, the court has just said that the prohibition on the use of force is jus cogens. But if you listen more carefully or you read it more carefully, you will notice that the court speaks about the unlawful use of force. The court speaks about violations of norms of, or rather egregious violations of norms of general international law. And the court speaks about jus cogens. At no point does the court connect these, right? At no point does the court say, these other egregious violations of norms of international law include the prohibition of the use of force, right? So it's a clumsy, convoluted sentence because the court wants to show that it has spoken about jus cogens and it has linked jus cogens with some norm, but the court never actually makes the link. The most famous way the most famous avoidance technique that I can point to is that the court often relies on erga omnes. And so there's this other concept, we call it the sister to jus cogens. I won't speak about it. But erga omnes basically refers to obligations that are owed to all instead of just bilateral obligations. So very often the court, in the past, when the court wanted to use jus cogens, but it couldn't, it would simply refer to the norm as a norm that produces erga omnes obligations. There are all kinds of theories about why the court has been reluctant to use jus cogens for a long time. That's not relevant for our talk, but maybe at some other point we can sort of explore the possibilities. The point is that jus cogens is now in the mainstream, but it's still really a concept or a norm that is stuck in the garage, in part because the International Court of Justice is reluctant to identify norms as jus cogens, which brings me to the second relationship between jus cogens and genocide. The first time that the court unconditionally and explicitly identified a norm as one being of jus cogens character, you will not be surprised to hear that it was in respect of the prohibition of genocide, right? So it was in a case between the Democratic Republic of Congo and Rwanda, which was instituted in 2002, and then in 2006, the court gave a judgment on jurisdiction. And in the course of that judgment, the court says that it is assuredly the case, and these are very strong words. I mean, the court could have just simply say it is the case, but it says it is assuredly the case that the prohibition of genocide is jus cogens. So again, um, genocide is responsible for bringing jus cogens from the periphery to the mainstream, but it looks like genocide is also going to be central to the court feeling free to refer to jus cogens. Um, that sounds like a happy story. I'm going to dampen the story just a little bit and hasten to add that this explicit and unconditional recognition of the prohibition of genocide as jus cogens was in fact not such a happy occurrence. Because in a sense, what the court did there was it gave with one hand, which is the recognition of genocide as, the recognition of the prohibition of genocide as jus cogens, but it took with the other hand, because essentially the court was saying it actually doesn't matter. So in the context of that case, the Democratic Republic of the Congo had instituted a case against Rwanda, and one of the claims were based on genocide. So it was based in that sense on the Genocide Convention because both Rwanda and the Democratic Republic were parties to the Genocide Convention, but Rwanda had made a reservation in respect of Article 9 of the Genocide Convention. And Article 9 of the Genocide Convention is that provision that gives the court, the International Court of Justice, jurisdiction over genocide-related cases. The DRC said it doesn't matter that Rwanda has made this reservation because the prohibition of genocide is jus cogens, and therefore it would trump Rwanda's reservation. Now, the court says something very interesting. The court says, responds to this argument by saying the fact that a dispute relates to compliance with a norm having the character of jus cogens, which is assuredly the case, cannot itself provide a basis for the jurisdiction of the court to entertain that dispute. It says under the court statute, that jurisdiction is always based on the consent of the parties. So this takes you back, in a sense, to that horizontal system, right? Horizontal system. So one of the essence of the horizontal system of international law is consent, consent, consent. Consent is at the heart of lawmaking. States are only bound to that rule which they have consented. And consent is also essential to the jurisdiction of the court, right? So again, the court gives with one hand, which is recognizes the prohibition of genocide as jus cogens, but immediately takes with the other, in that it says, it actually does not matter. You might remember there was another genocide case that was instituted just about a couple of months ago, 2 months ago, which the court has now already dealt with in Sudan versus the United Arab Emirates, in which Sudan was claiming that the United Arab Emirates is involved in the commission of genocide on its own territory, so on Sudan's territory. And on the basis of this reasoning in the 2006 judgment, the court said, well, it clearly doesn't have jurisdiction, and so it struck that case off the roll almost immediately. So this is a strong limitation, right? So it's a very strong limitation. A third relationship between the prohibition of genocide and jus cogens. The prohibition of genocide, in fact, in particular, the application of the Convention on the Prevention and Punishment of Genocide has led to important developments in the jurisprudence of the Court of the International Court of Justice relating to jus cogens. So in the context of its jurisprudence, the court has recognized the erga omnes character of norms such as the prohibition of genocide, and it has done so mainly in the context of genocide. So the first time that it did so, where the concept of erga omnes was really given effect to in a strong way, was in Gambia versus Myanmar, where the court said it has jurisdiction, even though the Gambia is not itself a quote unquote injured state in respect of the genocide that it complains of in Myanmar. This erga omnes character of genocide as a jus cogens norm is also at the heart and also serves as the basis for South Africa's application against Israel in the genocide case. And I think one can say the same as well about Nicaragua's filing in respect of its claim against Germany. There is a caveat, which I should put very quickly, and that caveat is I think that the court remains reluctant to refer to jus cogens. And so it's still, a typical example here, I could tell you in 2024, the court issued an advisory opinion in the situation. Yes, in 2024, in July 2024, the court issued an advisory opinion in the situation in Palestine, and they had identified self-determination as a norm of jus cogens, which is great because it was the first time that it did this. And then when it came to the consequences of the violation, the court did not rely on jus cogens, but instead relied on erga omnes. So there's still some reluctance on the part of the court to refer to jus cogens. One last relationship between jus cogens and genocide. If you're familiar with jus cogens discussions, you will know that one of the central questions is how to identify which norms are jus cogens, right? Because what you want to try to avoid is jus cogens being in the eye of the beholder. So everyone will choose their favorite norm and say this norm because is my favorite is a norm of jus cogens. So how to identify jus cogens is critical. From a purely positivistic approach, right? Identification of jus cogens is based on what the Vienna Convention refers to acceptance and recognition, or perhaps yes, acceptance and recognition that a norm is non-derogable by the international community of states. You will notice if you're careful that these words, acceptance and recognition, really bring jus cogens back to the horizontal structure of international law. Because what does acceptance and recognition mean? I guess acceptance and recognition mean that the consent of state, acceptance and recognition by state. So it's a way of taking this natural law concept, which is based on morality and based on ethics and based on values, and sort of taking out the values and taking out the morals and making it, again, a purely positivistic concept, which is consistent with the horizontal structure of international law. Adherents of the natural law approach tend to want to downplay consent, and so they tend to want to downplay acceptance and recognition, right? And they focus more on values. Between 2015 and 2022, the International Law Commission was involved in a project on jus cogens, and being involved in a project on jus cogens had to answer this question, and this question became one of the most difficult questions that the International Law Commission had to answer in the context of that project. In the context of that project, already in 2015, there was a proposal to include in the draft conclusions of the ILC a concept that said norms of jus cogens are those that reflect and protect the fundamental values of the international community. So you see, this takes it away a little bit from this acceptance and recognition. And of course, there was a huge debate. One of the things that helped us breach this debate or this division was something that the International Court of Justice said in 1951. In 1951, the International Court of Justice had before it a request for an advisory opinion on reservations to the Genocide Convention. So the extent to which reservations would be permitted to the Genocide Convention. Now, a couple of things that the court says, which became important for bridging this gap, is the court says, oh, and by the way, the court doesn't speak about jus cogens here, but it's these things that it's saying. It gives you the sense that certain rules like the prohibition of genocide, is based on values and morality. The court says the principles underlying the convention are principles which are recognized by civilized nations as binding on states, even without conventional obligation, right? So even without the consent of the state, essentially. And then it says a consequence of this is the universal character. Again, when you think about universal character, if you're an international lawyer, that tells you something about a natural law approach, something which is about values, right? It says the universal character both of the condemnation of genocide and the cooperation required in order to liberate mankind from such an odious scourge. And then the court says the object, this is the object of the Genocide Convention, is to safeguard the very existence of certain human groups, and to confirm and endorse the most elementary principles of morality. In such a convention, the contracting states do not have an interest of their own. They merely have, one and all, a common interest, namely the accomplishment of those high purposes which are the raison d'être of the convention, the high ideals which inspire the convention, provide, by virtue of the common will of the parties, the foundation and measure of all of its provisions. Right? So, littered in this little extract is references, hidden references to morality, universality, and so on, right? And this particular reference has been used by courts all over the world, in particular domestic courts, to come to the conclusion that Jus Cogens norms are based on values, are based on fundamental values of the international community. And it was this notion which comes from the International Court of Justice's advisory opinion on the on reservations related to the Genocide Convention that that the International Law Commission was able to sort of draw its bridge. So the bridge that it draws is, on the one hand, it sticks to the acceptance and recognition, but then there's a draft conclusion too, right at the beginning, which seeks to orientate the whole set of the draft conclusions, which says the draft conclusions, or rather, norms of Jus Cogens are based on the fundamental values of the international community. And in a sense, I think, and I will end with this, I think that this is the most fundamental element of the relationship. The most fundamental element of the relationship is this notion that Jus Cogens norms protect the fundamental values of the international community, and the prohibition of genocide is quintessentially a reflection of those values. And I will stop there and happy to take whatever questions that you might have.
Thank you, Professor Ditladi, for your wonderful presentation, and it was really interesting to see the legal foundations of your argument. And I was also happy to hear that you're connecting this discussion with international community, so we can discuss that later if you want. But I don't know if Felipe gathered some questions from the audience.
Not yet. We are receiving some questions now.
Okay. So I would like to ask if Professor Paulo or Arlene have questions, or otherwise I would make my own questions. So I don't know. I'd like to...
You have the floor. Go ahead.
Okay, so thank you for the opportunity of hearing your presentation, Professor Ditladi. Uh, Actually, was first of all, I have two questions, but we can discuss about that later. The first one would be, it was really interesting that you presented that the idea of Jus Cogens came as at the mainstream of international law due to the events of the World War II, and so the commitment of genocide. And that's why, in your argument, that's why the court might have been interested in using explicitly the idea of Jus Cogens only in genocide case involving genocide. So I wonder, just wonder if we could, to a certain extent, once again say that Jus Cogens at the beginning, although revolutionary, although having these miracle effects, we could also say that it has a basis on European own experience, own political experience. So of course, I know that genocide is not only related to European experience, but you said that that one of the reasons of having this introduction at the core of genocide convention, the idea of the use cogents. So I think it would be interesting to hear a little bit more if you could say that this would only reinforce the argument that contemporary international law is based to a certain extent to European political experience. That's the first question. And the second question, I would like to say that you said at the end of the speech of your lecture that we could say that the use cautions are related to the protection of fundamental values of international community. This would, as far as I understood, this would say that it could move, continue the movement towards not the non-horizontal character of international law. But then when you say the international, because now I'm thinking about the international community, not only the international community of states, but international community as a whole. So more than states, we're thinking about other actors, of international actors. And having that in mind, I would ask you if we consider other international actors such as uh, demonstrations and such as social movements. So do you think that we could expand the idea of use cogents or in this sense, dealing not only with states, but other international actors? Do you think if we broaden the idea of international community, not only to states, but considering international organizations, social movements, NGOs, and so on, we could expand the idea of use cogents to another norms and to reinforce the idea of genocide and use cogents? If I'm not clear in the questions, I can repeat them with another way. Thank you.
No, thank you very much. So Arthur, these are two really interesting questions that you have asked, and I'm of course not surprised. I'll start with your first question, which I think the answer is very easy. So people might not like it, but the fact is that international law is a European project. It was a European project. Um, the question is, what do you derive from that fact? And for me, I don't derive anything from that fact. It is the project is. I mean, if you think about Euskogans, if you think about the history of Euskogans from the very beginning, Euskogans, the concept, the phrase first arises in Roman law. Yeah, you find the concept of Euskogans not used in the same way, but you find it in the digest. And Roman law is your quintessential um, European legal system, the birthplace even of law in Europe. So I think it's not a stretch to say this. I don't derive any negative consequences from that. I have we often speak about TWAIL, and people ask me, and one of my difficulties with the TWAIL movement is the refusal to confront the legal system on its own terms. And to confront the legal system on its own terms, in particular the weaknesses of the legal system, I think requires that you accept that the project is or was initially a European project, and then you assume ownership of that project. And once you assume ownership of the project, then it really doesn't matter. I mean, I think, as you yourself mentioned, these things affect us. They affect us everywhere. We've had genocide on this continent. There's been genocide in Asia, and so that would be my first question to answer, which is yes. It reinforces it, but I don't think there's much that you can draw from the fact that it reinforces it. It's just simply true. I mean, even the quote from the 1951 Genocide Convention advisory opinion, the advisory opinion on reservation to genocide, it uses the famous phrase that normally gets my students very upset. Civilized nations. Ah, what a civilized nation. Of course, that's a heritage of Europe, and we all understand, what that concept meant. And now I think we have to take ownership of it and so on. Um, Your second question concerning the protection of fundamental values, I saw sort of two steps to that question. So one step is, um, can we extend um the international community from the international community of states to just the international community as a whole? Um, what the ILC draft conclusions do, and of course I had some hand in that, is they use both the international community as a whole and the international community of states as a whole. So if you look in the parts of the draft conclusions that concern, if you look in the parts of the draft conclusions that concern identification of Uskogan, so from draft conclusions 4 until 7, I think, it speaks about international community of states. So it speaks about acceptance and recognition by the international community of states as a whole. But where it speaks about values, right? So, for example, draft conclusion 2, which speaks about, Uskogan's norms are those norms that reflect and protect the fundamental values of the international community. It speaks about the international community as a whole. And there were many members of the commission that had argued that phrase should be made consistent with the phrase in the other draft conclusions. And I think it's part of this debate between a positivistic approach and a more open approach, right? So there's room for both, and the commentary to the International Law Commission, of course, explains this clearly. So that's my view. The second part of your question, or the extension from there, and this is where so the immediate answer to your first question is yes. Um, the second part of your question, this is where I would sort of hold you back a little bit, because in the second part of your question, you ask whether or not opening up the international community beyond states could lead to the opening up of a recognition of more norms. And I would say, well, maybe, but the question is whether or not that's a good thing. And I'm not sure that that's a good thing. I don't support the idea of, and that's why when people speak to me about the Inter-American Court, I don't embrace the fact that just about every norm is special. If we are all special to each other, then none of us are special. If we start identifying every norm as Uskogans, then it loses its specialness. So in a sense, so I think there's a value in limiting the number of Uskogan's norms to those that are absolutely core. So I wouldn't think that we should think about expanding the notion of an international community with the view to expanding the quote unquote list of Uskogan's norms.
Thank you, Professor Deer. And now I have received some other two questions. One comes from Brazilian Institute of Human Rights, Instituto Brasileiro de Direitos Humanos. And I'll read it, but if you prefer, I can also write here. But the question is, can a common article of the ICCPR and ICES self-determination lead to claims of use cogent norms within their respective jurisdiction? I can write it down for you if you want here in the chat. Your microphone is out, Professor Deer. Sorry.
I was saying, so the question is, can Common Article 1 of the ICCPR ICSCR lead to a claim of? So I missed the last part. Now your mic is off.
Sorry. So self-determination lead to claims of use cogent norms within their respective jurisdiction.
Okay, so I'm not sure I understand. So within the respective jurisdiction of states or of the conventions.
Yeah, because
Okay, it's written.
Yeah.
Okay, let me answer it this way.
Mm-hmm.
The right to self-determination, I've always argued is jus cogens. In fact, that's probably one of the things that got me most into trouble. Is the insistence that the right to self-determination is jus cogens. I don't think its jus cogens status flow from its inclusion in the ICCPR. I think its inclusion in the ICCPR and the ICSCR is very important, but I don't think that's the source of its jus cogens character. I think the source of its use cogens character, it's because of its acceptance. It's its broad acceptance and recognition by the community of states as a norm from which no derogation is permitted. I don't think, and this is one way to answer the question, if I understood it correctly. If the one way that one can understand the question is to say, eh, does the Common Article on self-determination lead to self-determination being use cogens? And I would say no, but I think it is a use cogens norm. It is a use cogens norm, but for other reason. The other way that I could understand the question, and that's why I wanted a clarification about what is meant by, within their jurisdiction. The other way that I could understand the question is whether or not the Common Article on self-determination can provide a justification within a state's territorial jurisdiction for secession. And there I would say, well, it depends, right? I mean, it depends on how one defines use cogens, because we often say that use cogens, we often say that the right to self-determination is use cogens, but very often we don't define what we mean, what is the scope, and its application. And I think it should be possible in the context of use cogens to say that secession under certain circumstances, so external self-determination, is covered by the norm by the use cogens character of self-determination. In its 2024 advisory opinion, though, the International Court of Justice was very circumspect and circumscribed in identifying the part of the right of self-determination, which is use cogens, and it said self-determination in the context of foreign domination amounts to use cogens. And so it didn't say self-determination is use cogens itself. It said self-determination in the context of foreign domination is use cogens. That, by the way, does not mean that the whole concept is not. It just means at that particular point, the court was ready only to identify one aspect of self-determination as use cogens.
I think that answers the second part of the question of Brazilian Institute of Human Rights, because it has asked, has the ICJ referred to this article in this context? But you have already mentioned something in the end of your answer response. And there's a question from Masego Haralaga from South Africa. He said, why do you think international courts still hesitate to actually use cogens even when they recognize it? And so this is the first part of his question. So why do you think international courts still hesitate to actually use cogens even when they recognize it? And the second part is, I think you mentioned it, courts avoid saying something in use cogens. Why? Does it not weaken the point of having such fundamental norms?
Yeah. So, I mean, I think those are related questions. And they take me into very interesting territory. The reason why the International Court of Justice in particular has been reluctant to refer to use cogens, well, there's a theory in the literature. The theory in the literature is that it is because French judges have traditionally opposed use cogens norms. So it's really because of, if you accept the theory, it really becomes about the dynamics and the fact that at least the argument is made. It's made so Arthur Urim, it's made by several authors, and interestingly, it's made by authors who are French themselves. So Hélène Ruiz Fabry has made the argument. The argument is also made. I forget her name, but in any event, that these French judges are basically opposed, and so because the French judges are opposed, it becomes very difficult to include it. That's one theory. I have another theory, which I've developed more recently is that there is a competition between the International Court of Justice and the ILC. That erga omnes, the concept of erga omnes, was created by the court, and so the court prefers to use erga omnes. And the notion of use cogens was brought into the periphery by the International Law Commission. So it seems as if the the notion that these two institutions are friendly, maybe that notion can be tested a little bit. Um, to the third part of the question, or the second part of the question rather, does it not weaken the concept? Yes, I mean absolutely. The reason why the car is still in the garage is precisely because courts, in particular the International Court of Justice, but not only the International Court of Justice, are very reluctant to use jus cogens. And I think if courts used jus cogens a lot more, it would be a lot more powerful and it would have a lot more of an impact.
Okay, thank you, Professor Deere. I think we don't have any more questions. I would like to ask if Professor Paulo, Professor Arlene, or Professor Philippe have some questions for you, because I have already made my one.
Oh, I don't know
What
if
I'd like to say,
Arlene, please.
Professor Paul, if I may, Professor Lippi, is that at first I'd really like to thank you. I've learned immensely. My field of study is Arab history. I'm a professor of Arab history, and specifically the history of Palestine and the Palestinian Jewish relations and so on. Well, Zionist, one may say, but anyway, I also go into Jewish history. So I just want to say that I've learned immensely, taken my notes, of course, and thank you very much your presentation. And I'd like to then give the floor to my dear friend, Professor Paulo.
Thank you, Professor Arlene. And thank you so much, Professor Dier-Tladi. It was illuminating to follow your lecture today. I do hope we have opportunity to work together again in the near future. As you said, that featuring genocide as jus cogens is mandatory to keep its weight and to stress that it cannot be transgressed. Unfortunately, we have ongoing cases of genocide, and this is very important to have these contents reaffirmed and very strongly stated by the International Court of Justice. So thank you so much, and I hope we have soon opportunity to be together again, even if remotely online like today. Thank you so much.
Thank you very much. Mucho obrigado.
Well, I have no questions. I only want to thank you, Professor De, for your lecture. It was very enlightenment and enrichment for myself. This discussion about genocide and jus cogens is a theme that touched me um, very much. It's one of my main themes of investigation, and it was really how can I say um hard touching your lecture. I had a lot of things that I pointed out here, and so I have to fresh it before having more questions to make it to you. Thank you very much for your speech and your lecture.
Well, thank you very much. Let me just again express my great appreciation for the invitation, and also congratulations for your project. So, Professor Paulo, you mentioned you hope that we would be working together. So Arthur and I have been working a couple of years ago on trying to get our two universities to collaborate, but well, things happened and I went somewhere else, and so we couldn't pursue that. But I'm hopeful that there's still some room for some collaboration, with at least some South African universities, maybe the University of Johannesburg, who knows?
Thank you, Professor Deere, for the
Thank you very much.
for sharing your experience and your contribution with us, for have reserved a part of our time with us to discuss these topics. I'm eager to have other collaboration and cooperation with other South African universities like Johannesburg. I would like to thank you on behalf of other organizers our presence here. So thank you once again.
Thank you. Thank you
And
very
we'll
much.
keep in touch. And
Yep.
of course, I'll keep talking with you after that. Thank
Thank you
you.
very much.
Have
Thank you so
everyone have
much.
a good afternoon or a good night for you all.
Yeah,
I
it's
don't know if night.
good
Yeah.
evening. Yeah, there's still a
Yeah.
lot of light, but it's still
Okay.
evening.
Okay. Good evening. Good evening
All
for you.
right.
Okay.
Bye-bye.
Bye.